Good afternoon. This is the Governor's Committee on People with Disabilities with the Accessibility and Disability Policy webinar series. Today we have with us Erin McCullough, and the title of the session is Title I of the ADA and Reasonable Accommodations, Reasonable Accommodation Requests, and what's happening to the ADA now that it's turning 29. So Erin, I'm going to turn it over to you. Thank you for joining us today.
All right, Randy, thank you for having me. I just want to confirm that you can hear me. And it appears, since I'm being captioned, that you can do so. I want to thank you and the Governor's Committee for inviting me to present. I want to signal at the beginning, and Randy, can you advance the slide, please, and advance it another time? That I want to indicate to everybody who was expecting Joe Bonke to present, if you were, in case you didn't know, the presenter that was scheduled to present today was a colleague of mine by the name of Joe Bonke, and he passed away less than 2 weeks ago. On October 9th. And Joe was a dear colleague, a great guy. And I'm going to talk about him a little bit at length. I was tasked or asked to and honored to fill in. And so I'm utilizing Joe's material with permission of his coworkers and his superiors at the EEOC. But I need to clearly indicate that while Joe would have presented something from an EEOC perspective, since I don't work for the EEOC, some of, I guess, the colored commentary that you might be getting from me is clearly my edits, and I will try to indicate that is the case. I have not significantly edited his presentation for content or flow or focus, again, trying to honor the folks that had signed up for his presentation. I have altered the contact information at the end of the presentation because, again, Joe is unavailable to answer your questions directly. So there is some more generic contact information for EEOC at the end. I'm going to spend a minute talking about Joe. I met Joe in the end of 1999. I was a law student, and I had started to work for what at that time was his immediate prior employer, what's now known as the Southwest ADA Center and was then known as the Southwest Disability and Business Technical Assistance Center. Had employed Joe for a number of years, from the early days of the ADA until such time as he went into private consultancy on the ADA, and before he started to work for the EEOC, I believe shortly, I think around 2001 or 2002. And he worked for the EEOC again for 17 or 18 years. We both lived in Houston. He still had a relationship with my then employer, where he was providing some free and contracted services. He was beloved when I took over handling the ADA hotline for part of the week. Often callers would be asking for someone else, and it would generally be Joe, because he had been a long-term beloved and reliable reporter on the ADA, an educator, and someone who provided a great deal of humor along with, and goodwill along with the technical assistance on this complex and sometimes very emotional subject. Joe is missed and will be missed. he is an extraordinary person. I have met, but not met all of his family, and they are lovely folks who I want to extend my good wishes to, particularly his wife Joyce and his children, who I've not met all of, but his children Jillian, Jordan, and Jackie, I believe. Any people in his extended colleague and friend group. His obituary is available on the Houston Chronicle legacy site, mentions in great detail in his wonderful life. And again, the great love of his life, his high school sweetheart that he married, Miss Joyce Bonke, and as well as his, work achievements and his civic engagement. Of particular interest, I think, is his regular role being one of the coolest Santas on the planet, and his hard work with his cooking ministry called His Disciples Cooking Ministry, an organization that prepares and serves meals for those needy people who have need of sustenance. So again, he was a remarkable person, and I'm honored to try to step into his shoes and to fill this role. And I assure you that any errors or objectionable content is mine and not his, because he handled this kind of work with a great sense of duty and goodwill and a politic and even spirit in, again, interpreting and explaining and educating about this really complex set of laws. So I apologize in advance, and but again, I'm happy to step in. Randy, if you could advance to the next slide. The Equal Employment Opportunity Commission is the federal agency that is charged with regulating in the employment arena, in both promulgating regulations that protect people in the workplace, in their protecting them in the application for work, in the course of their employment, and receiving the benefits of their employment, as well as engaging in enforcement activities to both encourage enforcement of these laws through outreach and education, which is what Joe did, and through direct enforcement actions, such as bringing a charge and lawsuit on behalf of individuals who have been discriminated against. The EEOC and the regulations that it has promulgated out of legislation that protects people covers 8 broad protected categories, or what you might see as protected classes or suspect classes discussed in various case law or other legal writings. And these broad categories include things such as race, the color of an individual, the national origin or where they were born, in protection against discrimination based on religion or creed, protection against discrimination based on sex, which has increasingly included awareness of the need to protect people based on their sexual orientation or their gender identity or their status as a person who self-represents as transgendered. Other protected categories include in our focus today, disability, protection against discrimination based on age for people who are 40 years and older. When I started in this practice, I was much younger and used to kind of laugh about that one. Now that I'm quite a bit older than 40, I'm grateful that these protections exist. And increasingly, the EEOC is promulgating regulations and seeing enforcement actions for protecting people against discrimination based on genetic information as both the science of genetics expands and the application of genetics even into our consumer space, our personal lives expands. So again, these are the broad categories, these kind of complex identities that all of us are going to fall into, one or many more of these buckets. And this is this complex arena that the EEOC, again, regulates and enforces in. And so, but today's focus is on disability. I do self-represent as an expert on the Americans with Disabilities Act. I have done some broader legal work around other discriminatory criteria, but I don't hold myself out as an expert. And again, you would have been better served with Joe here. Can you advance to the next slide, please? In 2017, the EEOC saw a total of 84,254 charges of discrimination filed. And of that, there were a total of 26,838 charges that included charges of disability that may have included other charges of discrimination such as race or age discrimination along with the charge of disability. There is some updated data that suggests that there are 24,605 charges of discrimination based on disability charged in this past year. This represents a somewhat consistent percentage of discrimination complaints of around 30% of all discrimination charges brought to the EEOC for potential enforcement have a component of disability discrimination in them. Again, in 2017, that was 31.9%. In 2018, there's 32.2%. And again, this kind of 28 to 32% has been pretty common for the last decade. So it is a significant amount of discrimination charges that involve disability, but again, not even typically a number two in terms of the types of discrimination. The number one, and detailed on the prior slide, was charges of retaliation based on someone seeking to participate in their protected equal employment opportunity rights, or being involved in participating in someone else's. So potentially someone who is willing to be deposed in a lawsuit that a coworker brought based on discrimination, and they themselves are discriminated against, or someone who is seeking their rights for accommodation and are discriminated against because they're seeking their right for accommodation. So the number one type of discrimination, the number one type of charge that the EEOC sees are charges that involve retaliation. Thank you. So the Americans with Disabilities Act was passed by Congress with a great deal of bipartisan support. In fact, at the time, it was considered a little bit politically risky to oppose it. By the time the better part of a decade of really good hard work had been put in behind the scenes to bring this in front of the president to sign on July 26, 1990, George Herbert Walker Bush, the then president, signed the ADA into law. And think about what your life was like at the time. My favorite quarterback, Joe Montana, was at the top of his game, rather than how he showed up when he came to my now local team, the KC Chiefs, a few years later, well into his the end of his career, when he was still performing well, but performing very injured. 1990 was the year that Nelson Mandela was released from prison after 28 years of incarceration in South Africa. I mean, just kind of set yourself back there. The Simpsons now again pushing, I think, 30 years, or darn close to 30 years of existence. First aired as its own independent show on Fox for the first time, as having been prior been a short on the Tracy Ullman show. The first Gulf War commenced that year. So this was a significant and interesting political and social period, and this was a huge monumental change in the approach to enforcing the rights of people with disabilities in a lot of settings. At the time I was in college, I was a social work major. I had a professor who was very interested in and was later a scholar about the ADA, who introduced my class to this law and indicated that it was likely to be the most significant civil rights law passed in our lifetimes. That remains to be seen whether that's still the case, but it certainly was a monumental and an incredible effort to put these changes in place. Why was it needed? Well, it was needed because there was a great deal of discrimination against people with disabilities, a long history of discrimination against people with disabilities in a wide variety of arenas, a lot of institutional discrimination against people with disabilities, a lot of discriminatory language written into law, a lot of discriminatory practices that were placing barriers in front of people with disabilities from being integrated into the communities that they wish to live in and did in fact live in. Can you advance to the next slide, please? Some of those discriminations were based on disproven mythologies around disabilities. I'm going to say that discrimination against people with disabilities comes from a different place than other types of discrimination. Under most circumstances, I want to believe that most people don't get up in the morning with hate in their heart against people with disabilities generally, the way that they may do so against someone of a different race or a different religious practice, or even a different gender. And I'm not saying that this never occurs, but it is. It comes from a different place. There's a great deal of misunderstanding about what disability is, about its impact on the people who have disabilities, about disability's potential impact on you as, let's say, an employer, or you as a member of a community alongside people with disabilities. Again, there's a great deal of irrational fear about disabilities. There's a great deal of social awkwardness when confronted with someone with a significant disability of a type that you've never had a familiarity with. I will acknowledge social awkwardness the first time that you're confronted with somebody who, for example, has a difficult time speaking. The first time that you're conversing with someone who's deaf via with a facilitator who's providing an American Sign Language so that you can communicate directly with that person who's deaf. I'll admit that it can sometimes be awkward to converse at length with someone who has a service animal. If you have, for example, a fear of large dogs and someone's using a service animal that's large. But there's a lot more, I'd say, widespread and onerous kind of mythology around disability. There's a great deal of fear that, again, that whatever is causing someone's disability might reflect badly on you, or that it may be catching. As ridiculous as that sounds, there's in some people is kind of underlying fear. There's also a great deal of, I guess, misunderstanding about what disability is. I've heard myths that people think that there's not that many people with disabilities. In the preamble to the Americans with Disabilities Act, that kind of launching language at the top of the legislation that was passed, it cited over 50 million people with disabilities as the Americans with Disabilities Act defines people with disabilities. The last census that we have full data on, the 2010 census, counts over 56 million people with disabilities in this country, over 300 million people. There's a great deal of, I think, mistaken mythology about the Americans with Disabilities Act itself. There's a great deal of confusion about who it covers. There's a concern that it covers everybody, and my answer to that is, well, it potentially covers everybody. The fact is that no, it doesn't directly protect everybody because it protects people with disabilities, but it is available to cover everyone if in fact you are a person with a disability, or you become a person with a disability, or you're someone with a disability who, let's say, for example, in the workplace doesn't presently need an accommodation, but may need one in the future. If your condition becomes more disabling, or the nature of your job changes in such a way that you may need an accommodation. In addition, there are, you may become a person with a disability. I think a phrase that I may very well have stolen from Joe years ago was, if you live long enough, you will become a person with a disability, whether you are one now or not. And that's undoubtedly true. At some point, age will affect your health, affect your mobility, affect your hearing, or affect your vision, or some combination of all that in such a way as to significantly impact you and significantly impair you. So the ADA doesn't cover everybody presently, but it is this law that will protect you if you need it and when you need it. There are a great deal of other myths about specific disabilities, and again, I think that's a completely separate presentation that I know Joe has presented before on disability etiquette and the mythology of disability. I have gratefully borrowed some of his content, and I think probably loaned him some in the decades past. Can you go to the next slide, please? But I want to draw you back to thinking about our country before the Americans with Disabilities Act. Before the Americans with Disabilities Act, depending on where you lived, you may or may not have had a lot of protections and a lot of access. Before there was a federal law that mandated basic access to your communities, to opportunities to apply for and potentially get a job, to access those arenas of public life that people without disabilities are able to access. Before that federal law existed, there was a sort of a crazy quilt expansion of rights for people with disabilities. There were some states and some localities that had offered protections, that had taken the steps to make sure that their public spaces, including those privately owned but publicly open spaces, those places of business, those places of public accommodation, had to be accessible to and usable by people with disabilities. But then you could go over to the next state and there would be no such protections. I lived for a significant amount of my adult life in Texas, and Texas had an Architectural Barriers Act aimed at improving accessibility for people with disabilities that predated the Americans with Disabilities Act by over 25 years. So Texas had made some pretty good strides in beginning to improve physical access, for the most part, for people with disabilities that impacted their mobility or their vision. Before the Americans with Disabilities Act, most hotels and restaurants weren't accessible to people who used mobility aids or who had vision impairments. There were far fewer curb cuts, those little ramps that are cut into sidewalks or or on the edges of raised pedestrian areas that allow for someone to bring a stroller or a wheelchair or a grocery cart safely over a raised paved area. In the early part, in the late part of the 19th century into the middle of the 20th century, there were a number of states and localities that had things that we call ugly laws, that are euphemistically called ugly laws. And these were laws and local ordinances that in a variety of ways prohibited people with significant and obvious disabilities from being out in public, often prohibiting people with significant, who had multiple amputations or significant disfiguring conditions, people who had been maimed and mutilated in war, people who were born with certain disabilities from being out in public during the light of the day, forcing disability into the actual darkness, presumably out of, again, either some moral belief or some again, to our era's, I think, just utter shock out of some belief that this was the right thing to do, that this was a protective thing to do. Again, while these laws were slowly rescinded or stopped being enforced, they were part of I think, the recent cultural history that led into the momentum for the growth of rights that led to the Americans with Disabilities Act's passage. In addition, and I think this is certainly still true, although less and less, you wouldn't see people with disabilities on TV shows or movies. You wouldn't see people living with disabilities in commercial advertisements. You very seldom saw people providing interpretive services, American Sign Language, for example, service on television or at public events. There were less recreational opportunities, including sports opportunities for people with disabilities. In effect, people with disabilities were hidden and excluded. And that was the specter that haunted everyone who lived, even without disabilities. At some point, you could become someone with a disability, and the way that you lived your life out in public, in the workplace, could radically change or disappear. Next slide, please. So a little bit of the history of the ADA. There's actually multiple origin stories to the Americans with Disabilities Act. There are some sister laws. The Federal Rehabilitation Act that requires all sorts of things, but is I think the parent or sibling law to the Americans with Disabilities Act, covers issues such as accessibility to federal facilities under its Architectural Barriers Act provisions, the behavior of federal employers, other accessibility concerns with regards to federal facilities and programs, was passed into law in the middle part of the 1970s, was improved in terms of enforcement in I believe 1978. However, again, that only dealt with the federal sector and that part of, let's say, state and local governmental entities and other grantees with direct federal money in the provision of those services or in the design and construction of facilities funded with that money. And it left a huge arena of public life without a set of enforceable laws. So there was an effort afoot to bring those protections into the accessing state and local governmental entities and accessing those privately owned but publicly operated spaces, those businesses that are open to the public, like hotels, like doctor's offices, like retail facilities, like recreational facilities. In 1988, there was a document that ended up becoming the Americans with Disabilities Act that was introduced into Congress. A great deal of negotiation with a number of remarkable individuals working in the in front of the public eye and the legislature itself, and certainly those people working behind the scenes. Joe has chosen to remark on Kai Feldblum, who was until recently a two-term commissioner with the EEOC, the Equal Employment Opportunity Commission, has commissioners. Ms. Feldblum was a law professor, may in fact be a law professor. She's currently and very recently a partner at the law firm of Morgan Lewis, having left federal service. She was a lead attorney on the team that drafted what became the ADA. In addition, I believe he has also pictured Patricia Wright, who was nicknamed the General for how well she kept the lobbying heat on Congress, working with her allies in Congress to keep this issue moving through committee and moving into a vote, and again, trying to coalesce support and get against the opposition to the passage of the ADA. Joe also threw a nod out to another key person, a leader named Lex Frieden, who was his boss's boss back in the day, and was my boss's boss back in the day. He is a vice president of Memorial Hermann Tier Hospital, who hosts the Independent Living Research Utilization Project, which he helped co-found. He is the lead over the Southwest ADA Center, which is a direct project of that program, the ILRU program. He is a professor, I believe, at Baylor Medical School. At the time of the passage of the ADA, he was executive director of the National Council on Disability, a federal agency that's charged with basically educating and providing policy to the federal government on disability-related issues. So he was at the time, working with the federal government, and one of the people who oversaw these early drafts of the law. So the law was introduced in 1988 and was passed by Congress and signed into law in 1990. So that history is pretty important, I think, to me, and it was certainly important to Mr. Bonke. Okay, if you could advance the slide, I'm going to move on to the next topic. Why is disability important? Well, I think I touched on this earlier, and Joe did certainly in his notes. And again, to steal that, I think I stole this quote from Joe, is if you live long enough, you will become a person with a disability. And so there's a certain mythology that that people are born with their disabilities, and undoubtedly a significant amount of people are born with a disability. The statistics suggest, though, that it's only about 18% or less than 20% of people are born with a significant impairment. But that number steeply rises with age, and I think for very obvious reasons. Age will tend to impact your ability to hear or hear well. It may blur your vision, it may and may impair your mobility. If you live long enough, you will become a person with a disability. But additionally, the longer that you do live, the higher your risk for certain potentially impairing diseases like diabetes or heart disease that may impair you enough to make you a person with a disability, and may impair you enough to where you are a person with a disability as defined under the Americans with Disabilities Act, and may be in fact in need of those protections. Additionally, if you live longer, you have more of an opportunity to do those really silly and risky things that may make you a person with a disability or may disable someone else. You may get into an auto accident that you cause, or you may have some other idiot, hit your car and injure you in such a way that you become a person with a disability. Additionally, there are some impairments that just don't always manifest when at birth or even at a younger age. And you can think of this as there are certain psychiatric disabilities that don't manifest, if at all, if they ever do, until later in life. And certain conditions such as MS that again don't tend to manifest until later in life. So the longer you live, the higher the likelihood that you're going to be a person with a disability. So I think, again, I can't gauge this audience's interest in the Americans with Disabilities Act since you're not in front of me, but when I'm in front of someone, a group of people, I tend to emphasize this point. No matter where you are and your awareness of civil rights and your commitment to civil rights and your belief that an expansion and a continued protection of civil rights is important, it is just good, cheap insurance with regards to the Americans with Disabilities Act. Because unless you are unfortunate enough to die young of something catastrophic while you are in perfect health, if you live long enough, you'll become a person with a disability. If you can advance to the next slide, please. I'm going to discuss this in brief. I suspect this might have been something that Joe could have spoken about more meaningfully. Again, I need to make it clear, I do not work for the EEOC. While I utilize a lot of their materials, while I respect the hard work of the people who have worked for the EEOC in the past and work for the EEOC now, I don't always agree with everything that occurs there. I don't always agree with how they deploy their resources. I admire the great work of everybody that I've worked with directly from the EEOC. But I don't hold myself up as an expert on their internal politics, their internal policies, and again, I'm not their employee. So Joe wanted to include a piece on the strategic enforcement plan, their forward-looking, long-term or somewhat long-term, let's say, guidance on where they're going to go. So in, I believe, October of 2017, they published their strategic enforcement plan, or their what they call their SEP, and it's an extensive, again, roadmap of how they intend to move forward with enforcing the mission of the EEOC in very specific ways. So if you can advance to the next slide. Please understand that the EEOC, again, is a regulatory body, and as much as they are required to create regulations or promulgate regulations to breathe life into the legislation that's passed by Congress and signed into law by the president, but they're also an enforcement agency, and they essentially operate as a national law enforcement agency, a national employment litigation agency, and they have offices that serve all 50 states and all the territories of the United States. And the needs of the population in these various regions can vary greatly. Again, the way that resources are deployed are going to be, sometimes best guess. I think you can imagine with there being volatility in the employment market, and I use, for example, the great amount of growth in, let's say, around Silicon Valley or the great amount of boom and bust in employment around, let's say, energy jobs, such as, again, like that was, for example, the North Dakota oil shale fields, where you have great shifts in over, let's say, a decades-long period of time, or in the case of the energy concerns, over a couple of years periods of time, where the workforce needs are changing rapidly, where there are a great deal in shifts in the kind of jobs people were doing and the location of those jobs. And the EEOC has to kind of anticipate, again, what's happening in terms of the changes in the actual law, what's happening in the change of the deployment of employees across the country. And when that occurs, what is going to tend to happen in terms of discrimination in the workplace. And so the strategic enforcement plan is a really long statement that shows their commitment to how they're going to deploy their resources, how they're going to spend their money, how they're going to focus on, I think, bang for the public buck on creating the most impact using the resources that they have. So it focuses on a variety of departments within the agencies and creating priorities that are focusing on laying out the priorities that they've identified in their plans and mapping a strategy to improve the experience of both employers and workers who are protected under these laws. And I hesitate to go into this. If you can advance it to the next slide. And again, I think while I'm not being an EEOC employee, I'm going to give this kind of short shrift. Joe probably would have spent more time on this. Because there was a change in administration, and there's a change in the party of the administration, there's undoubtedly going to be a change in how committed the EEOC is going to, or the EEOC is going to be to specific parts of that plan. When there's a change in administration, there's going to be at least eventually a change in the focus of these significant agencies underneath it. And I'll point to this. The ADA was signed into law in 1990. In 1992, Bill Clinton was elected as president, and as the chief executive, and basically inherited the approach that the EEOC was going to take in implementing these early stages of the ADA. So during the course of President Clinton's two administrations, you saw a great deal of action on enforcement of the ADA and in providing interpretive documents for the ADA. Throughout, again, his time in service from essentially when he was elected in 92 until the new president took his role over in 2001. Shortly after then, George Walker Bush came in to the office. The EEOC shifted some of its priorities away from the ADA into fair wage issues to a certain extent. I don't know exactly where the President Trump administration is going to take the EEOC. They have updated a strategic plan, not a strategic enforcement plan, in 2018 that is not dealt with in Joe's material and is a little lighter on detail. I think it stands alone as a separate document. It doesn't significantly doesn't significantly detail a repriority of, let's say, employee commitments, et cetera. The significant difference in the discussion of the language doesn't have a lot to do with the ADA. There is no mention of LGBT rights in the 2018 updated plan. The employment blog, the employment law, let's say social media space is speculating that the current administration will continue to focus on job growth, and they believe that the administration has signaled a commitment that the EEOC, I guess, firm up its commitment to more EEOC mediation. Now, I don't really know what that means in terms of longer term practical changes in the EEOC enforcement approach. Again, something Joe could have spoken to more meaningfully and done so very tactfully. Again, I'm not going to step into this because I probably, again, would be operating with less information. If you can advance to the next slide. At least with the existing 2017 to 2021 strategic enforcement plan still in place, some of its focus is, again, on reducing barriers to employment in recruitment and hiring. And we're going to talk about these a little bit more at length with some of these following case law on exclusionary policies and practices, particularly restricted to application processes, and screening procedures and policies that tend to discriminate or against people with disabilities, or tend to screen out people with disabilities for employment eligibility. I promise you we'll get to some case law around that. Again, that's a big focus of this strategic enforcement plan. Joe's notes suggest again that part of this, the way that they're going to show this commitment is focusing on those arenas of employment where there have been a great deal of traditional inequity in terms of who is eligible for employment, who is hired for employment, advancement within employment, with a particular focus on, again, is the expanding influence of technology employers, and I think a significant amount of clear evidence that there are at least some impacts in the way that they hire and promote that tend to reduce opportunities for women and for people of colors in those arenas. In addition, I think confronting the reality that law enforcement is an arena where the people who are holding the jobs in law enforcement at a lot of levels within local law enforcement and regional and statewide law enforcement, and even at the federal level, don't necessarily reflect the community of the people that they serve in terms of who's holding those jobs, who is promoted within, who is actually holding leadership positions. So that remains one of the focuses under the strategic enforcement plan. If you can advance to the next slide. In addition, the SEP indicates that or discusses the protection of vulnerable populations, including immigrant and migrant workers, getting those at-risk employees some protection, dealing with concerns about low-wage, stolen wages for undocumented employees, for people with disabilities, and for youth workers. The EEOC Los Angeles District Office recently settled a sexual harassment case against Barraza Farm Services and another business, Bornt and Son, that's B-O-R-N-T and Sons, for $300,000 for harassment of female farm workers. So again, at least at present, the EEOC is reflecting its commitment in the SEP for enforcing the rights of those vulnerable employees. If you can move on to the next slide, please. In addition, the SEP seeks to address emerging and developing employment discrimination issues. Those things nearly 30 years into the passage of the ADA that we're seeing as trends in the types of discrimination that are occurring. Again, the SEP bang for buck is looking at targeting inflexible leave policies that employers are subjecting employees to in violation of the requirements under the Americans with Disabilities Act Title I as amended under the 2008 ADA Amendments Act, with a particular interest in a commitment to the requirement that employers engage in an individualized assessment of the needs of somebody with a disability who's asking for a reasonable accommodation under the Americans with Disabilities Act, that an employer is showing a respect for the requirement that they engage in the interactive process of identifying whether an accommodation is reasonable and will actually meet the needs of a person with an employee with a disability to be able to do the essential functions of a job. In addition, the SEP and the EEOC's commitment to such is addressing qualification standards and essential functions and helping employers identify what are essential functions of a job and what are mere secondary or incidental functions of a job, and in developing some good technical assistance material on job analysis and job descriptions. For example, Joe cites a case where the EEOC sued the Grand Hyatt in 2018 for requiring, they refused to allow a front desk agent the use of a chair at the front desk, despite the fact that the employee had requested such and documented an impairment. It seems like such a simple accommodation request, a low cost, if not a no cost accommodation, but it was specifically denied. I think defending that is quite a bit more expensive than providing the accommodation. Again, Joe thought it significant enough to include here, so I did some research on it. If you can progress to the next slide, please. In addition, the 2017 Strategic Enforcement Plan reiterates the EEOC's commitment in protecting women who are pregnant or may become pregnant from discrimination. There's a certain intersection between the Pregnancy Discrimination Act, which is a separate law, and the Americans with Disabilities Act. And I'll talk about that in a little bit of detail, but I do believe there is an emerging bit of law around that. I actually did a webcast on this several years ago, and there's been several more since on this issue. If you're interested in some of those resources, I can point you to some pretty good guidance, and I think some pretty good secondary legal materials, not authored by me, authored by a law professor that I interviewed on this issue. The Pregnancy Discrimination Act protects women, I think obviously, again, who are or may become pregnant, and requires and prohibits discrimination based on the fact that a woman is pregnant or may become pregnant. The Americans with Disabilities Act deals with disabilities, and while pregnancy conceptually is not by definition a disabling condition, it is most often part of a natural part of natural, healthy biological development. But at times and under certain circumstances, pregnancy can impact the health of a pregnant employee, and create a circumstance where they are impaired at a level that arises to a disability, and they may be accorded some rights. The EEOC has interpreted the ADA to cover women under these set of circumstances. And I can provide just a quick thumbnail description. Again, the ADA kicks in if there's a pregnancy-related impairment that significantly impairs the employee. Such impairments may be things related to, like, say, what I think is unfortunately sometimes known as a crisis pregnancy, requiring where the health of the woman who's pregnant is impacted by secondary medical conditions related to the pregnancy, and the woman may need to be accommodated with some limited activities, including at work, to bring the pregnancy to term. There are some conditions that sometimes follow pregnancy. Some women who are pregnant do experience pain-inducing sciatica, and even pregnancy-related carpal tunnel, which may limit mobility and may need to be accommodated. Preeclampsia or gestational diabetes may also impact a pregnant employee in such a way that a reasonable accommodation might need to be provided. And if in fact an employee is requesting an accommodation under these circumstances, the good guidance would be to treat them as a person with a disability conditionally. That means as long as the condition is in place, as long as the impairment exists. And under most circumstances, many of those negative impacts for that class of women who are pregnant who experience this are time limited. If you can move on to the next slide. Another focus of the strategic plan is ensuring equal pay for all workers. An example of that is a 2018 action that the EEOC initiated against Uber and settled in August of 2018. The rideshare operator Uber was required to pay 56 workers $1.9 million for harassment and discrimination claims. Some of those claims were based on the policy of Uber on how it evaluated employees. The case was brought by 3 female Latina engineers who alleged that they were paid less than other colleagues, other white colleagues, other Asian colleagues, male colleagues. The women claimed that Uber used a quote stack ranking system that ranked employees based on certain criteria, but not necessarily actual performance measures, and that the rankings were used. The ranked employees made you eligible. So where you fell in the rankings made you eligible or ineligible for advancement or promotion or a pay raise, and that had long-term impact because future eligibility depended upon, again, past rankings. So I did not get an insight in reading the support materials and exactly how the ranking system operated, but it suggested again that A lower ranking from multiple years ago might impact this year's financial opportunities or advancement opportunities. So again, Uber settled that case for almost $2 million last year. If you can advance to the next slide. This is an ongoing concern. And again, the EEOC doesn't appear to have any active enforcement in this, although there have been a number of charges brought to the EEOC around this. The country's largest private employer, Walmart, has had a history of hiring older Americans and people with disabilities to work as door greeters. Walmart has changed its approach to, or this is their claim, Walmart is changing their approach to how that position is tasked, redefining the position, changing its titles, eliminating all the, which is in effect eliminating all the door greeter positions, and encouraging or allowing those people who have those positions to apply for a new, quote, customer host position. The customer host position is a significantly changed position, not just a change in title, which may require that employees be able to stand, to hold ladders, to lift somewhat heavy items. And again, since this was a position that a lot of older folks and a lot of people with significant disabilities hold now and have held in the past, its impact is going to be pretty wide and pretty deep. Many of those folks are facing difficulties acquiring the new positions or moving somewhere else within the organization, the Walmart organization, during this period of transition, and a number of them have brought charges into the EEOC. So I expect to see something moving forward, but Joe thought this remarkable enough to mention. If you can move to the next slide. The EEOC brought a case in 2017 and settled a case in 2019 with CRST Trucking, which refused to hire an otherwise qualified driver because that driver used a service dog. This driver applicant was a Navy veteran who used a service dog related to his post-traumatic stress disorder, his psychiatric disability. CRST, their partner training company, refused the hire due to a no pet policy, and because they basically just denied the applicant based on that. There appears to be no discussion of interactive process of doing an individual assessment on whether this person could be safely accommodated with their service animal in this position. The EEOC brought action again in 2017 and settled the case for 2019. If you can advance to the next slide. The picture at the top left actually shows the ceremonial signing of the Americans with Disabilities Act in July of 1990. But getting at the definition, who is protected under the ADA? The ADA, under Title I, the employment provisions of the ADA prohibits discrimination on the basis of actual disability. That is, somebody with an impairment that it's a person who has a physical or mental impairment that substantially limits one or more major life activities. So that means a person with a significantly impacting impairment, that it arises to the level of a disability under the ADA. In addition, the ADA protects people against discrimination based on a record of having a disability, whether or not they have a disability, and a perceived disability, or where someone has been discriminated against based on an employer's or a supervisor's perception that someone has a disability, whether or not they have a disability. The ADA Title I protects people against disparate impact or disparate treatment, rather. Treatment that is different than the employees without disabilities or applicants without disabilities. It protects people against retaliation. That means protects people against retaliations when they are asking for accommodations, or they are making a complaint to HR, Human Resources, or they are making a complaint to their state employment office or to the EEOC itself. The ADA and Title I requires that employers reasonably accommodate someone with a disability. And we're going to talk a little bit more about what that is. If you can advance the slide. What is discrimination under the ADA? Again, it's disparate treatment. Where a condition is not both temporary and minor, that means a broken finger, for example, that's likely to heal in a very short period of time, versus for example, the complete amputation of a hand. It means, disparate impacts when you're treating someone differently, when they're performing satisfactorily, when they're otherwise qualified for a job, when they can do the job. It means that you have engaged in an adverse employment action. That doesn't just mean firing somebody. That means failure to hire someone. That means discipline that's unlike the discipline that someone without a disability would face, or not providing access to some other benefit of employment based on disability, such as additional training that might lead to promotion, or other perks of a job, allowing someone, for example, to represent the agency and the organization on a traveling opportunity, or otherwise limiting their opportunities to perform the job because of disability in a way that might impact both their future pay and future promotional opportunities. Now, that doesn't mean that you can't discipline an employee who has a disability, that you can't fire an employee with a disability, but it needs to be a legitimate, non-discriminatory reason. It needs to be a reason based on actual performance, a reason based on actual conduct of an employee that falls below a reasonable and universally applied expectation of other employees, and is not, and the reason is not pretextual. It's not a reason that you, for example, make up, that you create whole cloth, or that you amplify out of a minor issue, or that you, again, that you apply disproportionately to the individual with a disability who may, for example, be already bringing a charge or a lawsuit. If you can advance to the next slide, please. In discussing retaliation, which is another prohibited activity, it's a retaliation if you treat an employee with a disability or someone who would otherwise be protected for engaging in protected activity. If you object to, say they objected to the discrimination that they're facing, they object to, they make a complaint to Human Resources, they request a reasonable accommodation, or they, let's say, write a letter in support of their coworkers' need for an accommodation, and their coworkers otherwise high quality work, and you discriminated against that person, they would be protected. Retaliation requires that an employee or some other person, the employee with a disability or some other employee, be subjected to a materially adverse employment action. That means an actual adverse employment action, such as, again, a write-up that they wouldn't otherwise get, a reduction in pay, a reduction in status, a reassignment, an actual termination of employment, or kicking someone out of some other promotional opportunity, that, such as further education. Again, this is different than some legitimate non-discriminatory reason that you might discipline an employee, that you might limit their eligibility for promotion because they may not be performing at the level of someone else, or they may not have met the reasonable expectations of the job, such as time in service or sales performance, that is, again, reasonable, related to the job, and universally applied. And it's not pretextual. That, again, it's not a made-up reason that sounds legitimate. If you can advance to the next slide, please. I think the brilliance of the ADA, and particularly in Title I, is the nature of this protection. It's or this obligation. Employers under Title I must reasonably accommodate a person with a disability. They must reasonably accommodate an individual who's disabled to perform the essential functions of a job, with or without. Let me back that up. It's not an affirmative obligation, but it's an obligation nevertheless. An employer must accommodate an employee with a disability who requests an accommodation, and the accommodation must assist that individual with a disability to perform the essential functions of the job. So under most circumstances, an employer is not required to affirmatively to accommodate an individual with a disability, but they must do so reasonably. And the reason I think this is kind of the genius of the ADA is it sort of spells out this give and take, and this that an employer must be willing to engage in to meet a person with a disability, and to meet their needs, and to allow them, again, the opportunity to apply for a job, to acquire that job, and to succeed and advance within that job as other employees without disabilities can too. And that obligation exists as a measure of reasonableness. I'm not going to go into detail about that, particularly it requires an individual analysis. It's balanced against the available resources of an employer to provide those. There's been a great deal of judicial discussion on what that is. And it's balanced against a claim of undue hardship, which I think is confusing legal language that does not mean the same thing as it might mean if you were having this discussion in your private home on whether something creates an undue hardship. As somebody who's provided technical assistance, who's advised employees with disabilities, and who have advised employers of people with disabilities, there is a tendency of employers to reach towards a claim of undue hardship. But I encourage you to understand that the EEOC regulatory guidance and the way that most courts have interpreted this, it doesn't mean that it's cost-free. It doesn't mean that it's without any administrative burden. It doesn't mean that to be able to assert it. It doesn't mean that it's a hardship if it's going to be an ongoing expense to acquire a piece of equipment or some adaptive aid or service. I can't provide a perfect bright line as where that's going to be. It might be an unreasonable accommodation, an undue hardship if you're not going to make payroll for a couple of weeks because of providing the accommodation. But the reality of it is that the vast majority of workplace accommodations are very low cost, which means $1,000 or less, or free. A significant amount of them are a change in attitude, or a reconfiguration into exactly how a job is done or when it's done, or just moving a piece of existing equipment closer to, for example, an employee with a mobility impacting disability. So some negligible or near cost-free accommodation is going to be is going to be the effective accommodation under most circumstances, or an adaptation of a policy. If you can advance to the next slide, I'm not going to get too deep in the weeds on that. So I'm going to respect Joe's outline here. Factors to consider in determining essential functions, which I think is best phrased as getting to a reasonable accommodation. How do you get to whether the part of the job that's presenting a difficulty for someone with a disability is an essential function? Whether the job exists to perform that function, whether there are others who can perform that function, whether the job is highly specialized and the person, for example, was hired for that particular skill set. Those are evidence of whether a function is essential. Employer judgment, the terms of written job description might actually be additional evidence. Someone was hired with that understanding. If that employee is a member of a union and the functions of particular subsets of employers has been spelled out in the collective bargaining agreement, that might be good evidence of such. Additional evidence mean you can look to what is the consequence if that a function is not provided, if that employee is not performing that function and no other employee can be tasked to perform that function. How critical is it to the functioning of the organization? The experience of current and previous employees on the job may also be telling on determining whether something is a essential function that may or may not be a requirement, such a requirement of the job that a waiver of that essential function is unreasonable on its face. If you can move to the next slide. So what is a reasonable accommodation? We've talked about this, we've kind of hit on the edges of this. It's a change in the workplace or in the way things that are customarily done. It's a change that's done because a person with a disability has either an inability to perform that function the way it is described and maybe the location it's prescribed, or using the tool sets that are in front of them, or doing so on exactly the prescribed timeline. Accommodations that might be available, that accommodations should be available. Reasonable accommodations should be offered to applicants with disabilities to be able to meaningfully access the application process, for existing employees to enable them to perform those essential functions that we discussed a little bit in the previous slide. In addition, reasonable accommodations should be available to enable an employee to enjoy the equal benefits and privileges of employment. And we mentioned previously, potentially, let's say outside of the workplace educational opportunities that are part of the management training program, for example, or sales training program, for example. If you can move on to the next slide. I'm running up on my time, I think, so I'm going to push through this pretty quick. Request for reasonable accommodations. Generally, an individual with a disability must request the reasonable accommodation. The request doesn't have to use any magic words. It doesn't have to be in writing. The request may come from a third party. It may come from an employer's wife or husband. It may come from a doctor. It may come from a union representative. It may come from an employer's direct supervisor, for example, taking that to HR. Again, there don't have to be any magic words that are used in this. Just someone has to indicate that they have a disability, that their disability is impairing them in performing this job or this part of their job, and they need some assistance on that. They don't have to spell out the specifics of how they're going to be accommodated, although they may very well do so. You can move on to the next slide. We're going to try to hit some of these real quick, some of these case law cases. What about attendance? Is that an essential function of a job? Courts have shown a great deal of deference to employers in the past on attendance requirements. You might understand why that is somewhat understandable. However, in 2017, the Sixth Circuit indicated that a call center worker at AT&T in Memphis reflects the needed to be accommodated, and attendance was not as, let's say, strictly necessary to every position. That the employer had maintained too rigid of strict attendance requirements, or rather, the employer had maintained strict attendance requirements, and let me back up. I've got better notes on this. This case actually indicates that there are some jobs that a person with disabilities are sometimes unable to perform. The nature of this person's disability was, I believe, anxiety. The nature of the job exacerbated her condition. It created a circumstance where it made it difficult for her to work, and she could not be accommodated around it. So in this set of circumstances, the Sixth Circuit indicated that a regular attendance was an essential function for this type of job. If we can move on to the excuse me, to the next slide. In Hostetler versus College of Worcester, the college hired the plaintiff as an HR generalist. At the time of her hire, she was pregnant. She disclosed her pregnancy and her plans for maternity leave. The college provided her with 12 weeks of unpaid leave under FMLA, despite the fact that she hadn't had time in service, but they had elected to do so. As she approached the end of her leave, she indicated that she had some medical limitations. The doctor only cleared her due to those medical limitations for a part-time schedule for a limited duration. She had worked with some coworkers to establish that she could perform the essential functions of her job on a part-time basis. However, the university and under these set of circumstances, or the college under these set of circumstances, elected to enforce a strict attendance requirement and elected not to accommodate her over the short term. The Sixth Circuit held that while regular in-person attendance may often be an essential function of a job, it's not an unconditional, it's not an absolute essential function of a job. And so the courts must hold a fact-intensive analysis on whether or not under this set of circumstances this person could not be reasonably accommodated, that part-time service under, again, let's say a 2-month or somewhat limited duration could be sufficient. It shows a failure of the interactive process, which we'll talk about a little bit more. If you can move to the next slide. In Mosby Meacham versus Memphis Light, and this set of circumstances, you had an employee who had asked to work from home for a number of weeks, again related to complications of pregnancy. The employer stressed that the physical presence was an essential function. The appellate court upheld the trial court or the jury's verdict on the lower court's decision, noting that while that physical presence was not an essential function for this type of job, this person was an in-house attorney. They indicated that the employer, under these set of circumstances, might be able to establish that working from home for a known duration might be a reasonable accommodation. Move on to the next slide, please. This is a slightly different case. Under this case, Guzman versus Brown County, the employee worked for a 911 dispatch office. She was fired after being repeatedly late. At her termination, she provided a doctor's note indicating that she had sleep apnea, which interfered with her sleep, which made it difficult for her to always be timely. Despite having 2 years prior received a medical clearance for a duty for fitness exam, under a duty for fitness exam, indicated that her need for additional sleep or need for a more regular schedule was less needed. This these are just kind of the back facts. The court basically sided with the employers, saying this was not the time. The employer, the employee only at termination brought this claim, and so the Seventh Circuit basically said that the claim is dead and it should stay that way because she's not shown that she had suffered from sleep apnea before her termination. She had not requested a reasonable, she hadn't requested an accommodation before her performance had suffered to the point where she was dutifully terminated. You can move on to the next case. Let's see. And for time, I'm going to cut some of these. EEOC versus Walgreens. This is a case where an employee was fired for eating a bag of chips, essentially accused of stealing a bag of chips. The employee had type 2 diabetes. Her claim is she had a hypoglycemic attack. She was approached by the security officer while eating the bag of chips and indicated, "My sugar low, not have time." Proceeded to eat the chips without further explanation of why she wasn't paying at that time. And the court, or rather there was a 2014 settlement indicating that there was some support for her claim that this was a reasonable response to a medical need, and that her termination was the termination based on her distressed condition was interesting. If you can proceed to the next slide. And so again, they settled rather than enforce that anti-theft policy. If you can skip to the next one, actually, and if you can skip all the way to slide 34, I believe it's EEOC versus United Parcel Service. There you go. The EEOC here, the EEOC brought a charge in, I believe, 2016. They had established, they created a settlement with United Parcel Service in 2017 for $2 million. The EEOC alleged that the UPS violated the ADA by failing to provide reasonable accommodations. And they alleged an inflexible leave policy where employees were automatically fired when they reached 12 months of leave without negotiating or engaging in an interactive process to discuss the reasonableness of extended leave. It's the inflexible leave policy as evidenced by that automatic termination that I think created the discrimination, and again, they settled. It's a failure of the employer to initiate and engage in an interactive process when an employee with a disability has requested an accommodation. So they failed to address in an individualized assessment in an interactive process a need to accommodate. If you can move on to the next slide. Another example of inflexibility is EEOC versus American Airlines and Envoy Air. The EEOC alleged that American Airlines and Envoy Air violated the ADA by requiring their employers to return to work, to have zero restrictions, to be perfectly healthy before returning to work following a medical leave that they were otherwise lawfully allowed to have. And so this exhibited an inflexibility, another example of inflexibility. The 2017 settlement was for, for $9.8 million in stock, which would be valued at $14 million, or his note indicates at $14 million today, if cashed in. In addition, there was some additional 2-year decree and injunction against this type of disability discrimination, a requirement that they clarify and adopt better policies about providing reasonable accommodations and mandatory training. If you move on to the next slide. in the inflexibility, I guess the inflexibility chain here. Another EEOC case that was brought, I'm not sure when it was brought, but it was settled in 2018. The employer maintained a policy that that employees had to be 100% healed again before returning to work after a medical leave. In addition, allegedly some employees were terminated due to their disability or association with people with disabilities. This led to a $3.5 million settlement in 2018 to compensate those victims of that discrimination. Excuse me. If you can move on to the next slide. This details a case of EEOC versus Murphy Oil. Murphy Oil is the gas station that's often in partnership with Walmart in the parking lot of big Walmarts across about a 20-state region, I think. So a pretty common feature in a big chunk of America. Murphy Oil required an employee who had serious back injuries, rising to the level of disabilities, to perform functions without accommodation that violated work restrictions. They denied accommodations that the employee had requested. And again, they settled in 2018 for $100,000. And Joe's note is the lesson of failure to make adjustments for the manager's physical impairments resulted not only in the loss of a solid employee, but $100,000 plus undoubtedly attorney's fees, et cetera. If you can move on to the next slide, slide 38. This is another example of inflexibility in return to work policy. And this set of circumstances, the language is they had a policy that an employee returned without any restrictions, and that an employee be 100% ready to return to work. So no indication of a willingness to accommodate an individual with a disability. So creating a pretty obvious setup for discrimination against people with disabilities. So again, inflexible cookie cutter policies lead to discriminatory and actionable behavior that ended up costing $832,000 and change for Associated Fresh Market. So yeah, I'm going to go ahead and skip to slide 40, EEOC versus Home Depot, and I think we're going to have to call this one the last one to allow for some questions. Joe has a number of other cases detailed on that. I believe that you can peruse those yourself if you have any additional questions about that. I'm happy to address that with you offline. But I want to address this particular case. It's a 2018 case, EEOC versus Home Depot. Here, a Home Depot employee who had suffered from irritable bowel syndrome left her station to go to the restroom and was fired for abandoning her station. She had requested that she be allowed a break. They had required that she not leave her break. So to prevent herself from soiling herself due to the nature of her condition, she was fired. And again, this is an example of an employee and probably a lower level supervisor who got the employer in trouble by strictly enforcing a policy showing a lack of common sense and compassion and costing the company $100,000 plus attorney's fees for something that even despite disability should probably be accommodated. I'm going to go ahead and skip to the end. I want to encourage you, again, if you have questions, to contact the EEOC at Twitter at EEOC _ Houston. If you have questions about specific accommodations, accommodating people with a particular type of disability, from vision impairments to hearing impairments to learning disabilities, etc., I encourage you to review the content at the Job Accommodation Network, or JAN, and we provided all their contact information there. They are extraordinarily awesome people and really smart. They have great fact sheets about specific disability and some general issues on disability at askjan.org. In the last page, other contact information. I provided the generic contact information for the EEOC on page 45. And again, this final picture of Joe. I apologize for running over time. For me, it was an opportunity to kind of pick Joe's brain after the fact. His notes were pretty copious in here, but they were in, to a certain extent, a shorthand. If you have any questions, I will honor my agreement and follow up. But if there's time to ask some live questions, please do so now.
Aaron, we do have a couple of questions. Are companies allowed to, and I know we're over time, so if you can't hang on, we understand. You can go ahead and disconnect. Are companies allowed to pay someone with a disability lower pay? In mental health, there are peer positions, which requires you to have the lived experience of mental health, and they are told they get paid less because they are a consumer. Sometimes even the janitor gets paid more than the peer. Does that make sense?
I think you're talking about the quote sheltered workshop set of circumstances or some parallel opportunity. This is a disputed bit of law, and I'm going to say that where there are programs that, vocational programs of other organizations or vocational rehabilitation programs that are working with individuals with disabilities, there has been a trend in the past to pay those people with disabilities a lower rate, sometimes even a sub-minimum wage.
Okay, this is not, the person just popped back in and said this is not vocational. So
then I'm gonna, if they can render some more specific facts in an email, then I won't be speculating blind on this. But it's an interesting topic, and I assure you,
I'll make sure everybody has your email address as well.
Please do.
Send out the materials.
But to that questioner, I promise you I will get you some more information. If you feel free to anonymize the specifics of who this organization is and where they are exactly. But if you can give me a few more facts offline, I will get back with you and with your permission, forward that information to Randy to post publicly.
All righty, we'll do that. Another question, if an employer reaches out to an employee who is perceived to need an accommodation, who objects to the interactive process, how would you recommend we proceed? Well,
that's an interesting set of circumstances. If an employer is observing that an employee is, let's say, struggling to perform essential functions, then it may be appropriate that they address that with an employee, as in, let's say, as they would with any other employee, and let's say a mid-year evaluation of their improvement goals or their personal employment goals. It gets a little more difficult when you have an employer who's kind of prescribing the needs that they feel that an employee has and how they could meet them, and it may be very heartfelt. And I mean, I say this because I'm aware of fact-based scenarios where this has occurred. No employee with a disability is required to accept an accommodation. You are not required to use an accommodation. You can elect to do a job without an accommodation. You still have to perform the essential function. So this would be a very delicate set of circumstances. A lot of smaller employees are very intimate. There's a great deal of, let's say, blend between workplace and social life in some small employers. I've certainly worked for some of these types of employers, and I encourage you to tread lightly, but understand that they have absolutely the right to refuse an accommodation.
All right. I don't see any more questions right now, but
I ran over time on that one, so
I understand. But
please,
so we'll make sure that everybody gets your contact information, a copy of the PowerPoint, as well as a copy of the captioning transcript.
Okay, and again, I do appreciate the opportunity.
Well, thank you, Aaron, for joining us today, and thank you all of our, we had quite a large number. I appreciate you hanging in there till the end. Have a great rest of the day, and we'll see you at the next session. Take care.
Thank you very much.